Legal remedies, important Supreme Court judgments and practical guidance. In parts 1 and 2, we understood the meaning of an FIR, the meaning of a complaint, and the procedural differences between the two. In this final part, let us discuss the most practical and legally important questions that every citizen should know. This part explains the remedies available under the law, the role of the courts, and the important principles laid down by the Supreme Court. We are proud to have crossed 1 lakh subscribers and received the YouTube Silver Creator Award. Thank you for your trust and support. Please subscribe free for more legal awareness videos. If you'd like to support the channel, you can become a member for 59 rupees or 119 rupees by scanning the GPay QR code on the screen. Now, let's begin today's topic. What if the police refuse to register an FIR? This is one of the most common grievances faced by citizens. A person approaches the police station to report a cognizable offense, but the police refuse to register an FIR. What should the person do? The law provides remedies. Under the Bharatiya Nagarik Suraksha Sanhita, 2023, BNSS, where information relating to the commission of a cognizable offence is not acted upon by the officer in charge of the police station, the aggrieved person may approach the Superintendent of Police, SP, by submitting the information in writing or through electronic communication. If the Superintendent of Police is satisfied that the information discloses the commission of a cognizable offence, the SP may either investigate the matter personally or direct a subordinate police officer to register the FIR and investigate the case in accordance with law. Thus, the law provides an effective administrative remedy before approaching the court. Can the magistrate help if the police do not act? Yes, if appropriate action is still not taken, the aggrieved person may approach the competent magistrate. Subject to the provisions of the BNSS and the facts of the case, the magistrate may exercise the powers conferred by law, including directing an investigation where legally permissible or proceeding with a complaint in accordance with the prescribed procedure. This judicial remedy ensures that genuine grievances are not left without legal recourse merely because the police initially declined to act. Landmark Supreme Court Judgment. Lalita Kumari vs. Government of Uttar Pradesh, Constitution Bench. One of the most important decisions on the law relating to FIR is the Constitution Bench judgment of the Supreme Court in Lalita Kumari vs. Government of Uttar Pradesh and others, reported in 2014 to SCC 1. The Supreme Court laid down the following important principles. Where the information clearly discloses the commission of a cognizable offence, registration of an FIR is ordinarily mandatory. The police cannot ordinarily refuse to register an FIR merely because they doubt the truth of the allegations. However, in certain limited categories of cases, a preliminary inquiry may be permissible before registration of the FIR. Such categories may include certain matrimonial disputes, commercial transactions, medical negligence cases, corruption cases, and cases involving abnormal delay in reporting where the facts justify such an inquiry. The preliminary inquiry should be completed within a reasonable time and should not be used to defeat the statutory right of a citizen to have an FIR registered where the law requires it. The BNSS also recognizes limited situations in which a preliminary inquiry may be conducted before registration of an FIR. Thus, the principles laid down in Lalita Kumari continue to guide the interpretation and application of the law. Can a false FIR be registered? Unfortunately, yes. The mere registration of an FIR does not establish that the allegations are true. An FIR records only the earliest information received by the police regarding the alleged commission of an offence. Its truthfulness is examined during investigation and, ultimately, by the court during trial. If the investigation reveals that the allegations are false or unsupported by evidence, the police may submit an appropriate final report before the magistrate. Knowingly making false allegations may also expose the informant to legal consequences under the applicable provisions of substantive and procedural law. Can an FIR be quashed by the High Court? Yes. The High Court possesses inherent powers under Section 528 of the Bharatiya Nagarik Suraksha Sanhita, 2023, BNSS. In appropriate cases, the High Court may exercise these inherent powers to quash an FIR or criminal proceedings where continuation of the proceedings would amount to an abuse of the process of law or where the allegations, even if accepted at face value, do not disclose the commission of any offense. However, this is an extraordinary jurisdiction. The High Court exercises this power sparingly and with great caution. Ordinarily, disputed questions of fact are left to be decided during investigation or trial. Which is better, an FIR or a complaint? There is no universal answer. Neither remedy is inherently superior to the other. The appropriate remedy depends upon the nature of the alleged offense, whether it is cognizable or non-cognizable, the statutory provisions applicable to the case, and the facts and circumstances of each matter. Where immediate police investigation is necessary, registration of an FIR is ordinarily the appropriate course. Where judicial intervention is more appropriate, or where the law contemplates proceedings before the magistrate, a complaint may be the proper remedy. The choice is governed by law, not by personal preference. Common misconceptions. Let us now clear some common misunderstandings. Misconception number 1. Every written application given to the police is an FIR. Reality: no. An FIR is a specific legal document registered in accordance with the BNSS when the information discloses a cognizable offense. Misconception number 2. Registration of an FIR means that the accused is guilty. Reality: absolutely not. An FIR merely initiates the criminal process. Guilt or innocence can be determined only by a competent court after due process of law. Misconception number 3. Every FIR results in immediate arrest. Reality: no. Arrest is governed by law and depends upon the facts of each case. Registration of an FIR does not automatically justify arrest. Misconception number 4. A complaint case has less legal value than an FIR. Reality: incorrect. A complaint is a legally recognized mode of initiating criminal proceedings before a magistrate and, in appropriate cases, is an equally effective legal remedy. Friends, before we conclude this comprehensive 3-part series, let us quickly revise the most important differences between an FIR and a complaint. FIR versus complaint. Quick revision. An FIR is registered by the police, whereas a complaint is filed before the competent magistrate. Generally, an FIR is registered when the information discloses the commission of a cognizable offense, while a complaint may be filed before the magistrate in appropriate cases as provided under the law. After registration of an FIR, the police ordinarily commence the investigation in accordance with the provisions of the BNSS. In a complaint case, however, the magistrate first examines the complaint and then decides the appropriate legal course in accordance with law. In an FIR case, the investigation generally begins soon after the FIR is registered. In a complaint case, the court first considers the complaint, examines the complainant where required, and thereafter decides whether further proceedings or investigation are necessary. After completing the investigation in an FIR case, the police submit a charge sheet or a final report before the competent magistrate, depending upon the evidence collected. In a complaint case, after considering the complaint and the material placed before it, the magistrate may issue process against the accused or pass any other order that is legally permissible. Therefore, friends, always remember one simple principle. An FIR ordinarily sets the police investigation in motion. A complaint ordinarily initiates judicial proceedings before the magistrate. Both are valid legal remedies recognized under the law. The appropriate remedy depends upon the facts of the case and the provisions of the Bharatiya Nagarik Suraksha Sanhita, 2023, BNSS. This one principle will help you understand the entire difference between an FIR and a complaint. Now, let me share a few practical suggestions that every citizen should keep in mind while dealing with criminal proceedings. Practical legal advice for citizens. Whenever you become a victim of an offense, remain calm and act promptly. Preserve all relevant documents, electronic records, photographs, videos, messages, and other evidence. Report the matter without unnecessary delay. State only true and accurate facts. Do not exaggerate or suppress material facts. Cooperate with the investigating agency or the court. Seek proper legal advice wherever necessary. Timely and truthful action often plays a crucial role in protecting legal rights. Final conclusion. Friends, always remember one important legal principle. An FIR and a complaint are not competing remedies. They are two distinct legal mechanisms recognized by law for initiating criminal proceedings. An FIR ordinarily sets the police investigation in motion in respect of cognizable offenses. A complaint ordinarily invokes the jurisdiction of the magistrate, who proceeds in accordance with the provisions of the BNSS. Understanding the distinction between these two remedies enables every citizen to choose the appropriate legal course and effectively protect his or her legal rights. Knowledge of the law is one of the strongest safeguards against injustice. Disclaimer. This video is intended solely for legal awareness and educational purposes. The facts of every case are different, and the applicable legal provisions may vary depending upon the circumstances. Therefore, before taking any legal action, you should consult a qualified legal practitioner for advice based on the facts of your particular case. Thank you for watching this video. If you found this information useful, please like the video, subscribe free of cost, and share your views in the comments. For more legal insights, do not forget to press the bell icon. I shall meet you again soon in the next video. Jai Hind. Jai Bharat.